on this morning's docket. That is case number 109208 in the interest of NAC.
May it please the court, with the court's permission, I would reserve 5 minutes of rebuttal time.
5 minutes is granted.
According to 38-2201, the Kansas Code for Care of Children is to be liberally construed to carry out the policies of the state, which are in relevant part make the ongoing physical, mental, and emotional needs of the child primary considerations in proceedings under this code. In addition,
But can you create that best interest yourself? I mean, can you delay matters in order to create an opportunity to develop a bond, foreclosing others to do so, and then claim best interest of the child?
it is up to the agency in order to protect the best interest of the child along with the court and the guardian ad litem. There was nothing in this case that my clients could have done to prevent a bond. In fact, that was one of their major concerns, is that there were relatives who had expressed an interest and that nothing had been done, even though things could have been done much sooner, which kind of takes me to my second point from the policy considerations, is to acknowledge that the time perception of a child differs from that of an adult, and to dispose of all proceedings under this code without unnecessary delay. Considering the policy decision or considerations, it couldn't have been the intent of the legislature to make post-termination custody decisions subject to appellate review, because in a case such as this, where it's gone extremely quickly, it's still been a year and a half. The argument before the district court was in November of 2012 when the child was 1 year old.
What's the appellate remedy for the maternal cousins then?
That is up to the legislature. In fact, in the DMM case, which was decided in 2007, the Court of Appeals notes that it creates a very harsh remedy, or it creates no remedy for relatives who find themselves without consideration, and then goes on to say, but that is the responsibility of the legislature to create a remedy.
What about the remedy for the child? What if the court had decided to terminate SRS custody and place the child with a convicted pedophile? I mean, there was no home study requirement or anything like that. They were foster parents, but if the court had placed this child with a convicted pedophile and consented to adopt, and there's no appeal, how is that in the best interest of the child?
Well, Your Honor, I don't know about that hypothetical, because in this case, both families did have approved home studies. I guess that's a legislative remedy also. 38-2270 under custody for adoption allows the court to do a direct placement. It also acknowledges that a child can be placed with a fit and willing relative, but then also couples that to the extent that that placement is in the best interest of the child.
My overarching question is, the proceeding was a determination of whether the agency had made reasonable efforts / progress towards the placement of the child. Now, why does which placement is best come into that calculus?
Because a decision that is made in the reasonable efforts imply that a decision is going to have to be in the best interest of the child. It's not simply the mechanics of going through a process. The decision that is reached has to be in the best interest of the child.
Well, let me ask you this. The SRS made an agency determination that placement with the maternal cousins was in the best interest of the child, correct?
Correct.
Was that reviewable by the district court? Did the district court have authority to trump that determination?
That decision was reviewable under 382264H, which requires a district court to continue to conduct permanency hearings in a child in need of care case. And the statute specifically states to review progress towards adoptive placement or placement with a permanent custodian or placement with a fit and willing relative.
Well, that's where I'm getting to, is there is a procedure whereby the best interest of the child determination can be reviewed. Why is it reviewable under the reasonable efforts paradigm, which addresses a whole different thing? It addresses child time, not who's the best placement, but child time. Are we following the federal mandates about getting these things done?
Well, it is part of the federal mandate under the Adoptions and Safe Families Act that imposed the requirement for permanency hearings.
I understand that. I'm talking about procedurally. If this had been done at the based on the permanency hearing, but it was done in a reasonable efforts proceeding.
Correct, because the statute and the prior case law states that if the court makes a finding that reasonable efforts have not been made, that allows the district court to go in and change its prior orders. In this case, the district court had made a prior order of custody to SRS, which is now DCF, for purposes of adoption. But by making a finding that the agency had not made reasonable efforts towards finding an adoptive placement, that allowed the court to go back in and, instead of doing the placement with the agency, to go into a different part of 382270 and do a direct placement with the foster parents.
Which do you think comes first, the discussion of mootness or the discussion of jurisdiction when we take a look at the Court of Appeals decision?
Well, mootness is an interesting issue since it's not properly before the court. It was not an issue that was ever raised. It was something that came out in the oral argument at the Court of Appeals level. But I think that jurisdiction is really more important because right now, as the case law stands, we have a split panel. We have a split in the decisions of the Court of Appeals. And this is a case that is capable of being replicated. So it is extremely important that this court make a decision in terms of, is there appellate jurisdiction in a dispute, a post-termination custody dispute.
And why isn't this a disposition?
I would argue that it's not a disposition because the legislature did not call it a disposition. In 382270, which is the specific statute that the judge made the order under, it's called orders for custody. I just look at the plain language of the statute.
Why isn't it a temporary custody? He pulled the child out of SRS and made a custody placement, which by necessity was temporary until the adoption made it permanent.
The Court of Appeals has previously found that...
Tell me under the statute why statutorily it's not the statute says any temporary custody order, does it not? And why isn't this an any temporary custody order statutorily?
I would argue that this is not an order that was temporary in nature, that temporary custody is a term of art that refers specifically to hearings that are conducted pre-adjudication.
Let me pile on to that theme a little bit. Because under subsection H of 2264, the district court or the sync court, I want to be clear about which court we're talking about here. So the sync court can revisit that custody determination at any time, which is what it did in this case.
Yes.
So why isn't that temporary custody?
I just go back to the temporary custody, I mean, has been defined as a term of art, and that it wasn't temporary custody. This was looking at reasonable efforts post termination of parental rights.
Is it defined in the statute, or is it defined as a term of art in the case law?
I think both, that it's been defined both ways. It's disposition that's not defined, but temporary custody has been defined in the statute. But it's also been defined in the case law and a series of published opinions in the Court of Appeals as these definitions are all terms of art.
Returning to the question of mootness, it seemed that you felt like it was inappropriate for the court to raise mootness on its own. And why do you think that that's not a issue that the court should examine?
I think the court should examine the issue of mootness today. I just don't think it should be a primary issue. And even if this court were to find that the issue is moot, that it should go on to rule on the jurisdictional issue, since there now is a conflict with the Court of Appeals.
In fact, jurisdiction has to be primary, doesn't it?
Yes.
It has to come first. Right?
Yes.
So we might reach mootness. You're just saying you don't go there first.
I'm just asking this court not to go there first, because as the situation stands, there are some cases saying that this order is appealable, or there's one case saying it's appealable, and then there's a series of cases saying it's not, and litigants need that kind of clarity. I mean, these are very important cases. The stakes are huge. It's very emotional. We have the situation of trying to get a permanent home for a child who's now been under the supervision of the court almost her entire life.
Could we talk about the merits of the mootness? A consent to adopt from the natural parents is a jurisdictional requirement in adoption proceeding. Would you agree?
Yes.
And here what we have is a court order that takes the place of the parental consent.
In the adoption statute, it does allow for consent by a judge in a sync case.
And that takes the place of what would have been the natural parents' consent if they had not been terminated.
Correct.
So why isn't the court-ordered consent a jurisdictional requirement in the adoption proceedings here?
I'm sorry, Your Honor, I don't understand the question.
Is the judge's order that's being appealed that consented to the adoption of this child, is that the validity of that consent a requirement for the validity of the adoption?
That was my opinion when I filed the adoption, but after having the oral argument with the Court of Appeals and further research, the statute allows that the decisions of the district court remain in full force and effect until a higher court decides otherwise.
But it can only make temporary orders. It can't make permanent orders.
But the orders that the district court made weren't in disagreement with its underlying orders. They were consistent. The court ordered placement for purposes of adoption.
Let's back up. If someone wanted to file, if maternal cousins want to file a 6260B motion or petition and allege that this adoption was void and invalid because the judge's consent at the time was not valid because it was upon appeal, would that be, not the merits of that, but why wouldn't that be relief that could be possible?
I think that relief could be possible, but that's
And
not what
if there is
happened.
possible relief, why is it moot?
It's moot because they didn't do that. Because they did have notice that the adoption had been filed. They had
No,
a
but
case.
you can file a 6260B for relief from judgment at any time if the adoption is rendered void. Any time. And so if they get a determination from this court that that order of consent was invalid, then that makes the adoption invalid, and they could go back and collaterally attack with the 6260B motion, which means that mootness means there's no possibility of any kind of relief if you get what you asked for. What I'm saying is, I don't think that's the case here, because there would be a possibility to pursue an avenue of relief from the adoption, even though it's already done.
This adoption's been final for 1.5 years now. It just seems that the state has an overriding interest in making adoptions to be final and permanent situations and not to allow
Well,
them to be unduly complicated.
Did the legislature say 6260B does not apply to adoptions?
No.
Or they could have, and they didn't. And so that's what I'm just getting to the point here of not how it's all going to play out or who's going to win. I'm getting to the point of mootness only means if what we do isn't going to change anything. There's no relief that can be obtained.
Well, there is an argument to be made, though, that now that the child's been adopted, the child is no longer a child in need of care. But I'm out of time.
Well, but that presumes that the adoption is valid. If you invalidate the adoption, how does that continue the invalidation of the Sink case?
The court had the authority to give consent. The case had not been docketed with the Court of Appeals, and the order that the judge made was consistent with his prior order.
In that regard, why was the juvenile division handling a probate division case?
That is standard procedure in Sedgwick County, that although adoptions are filed in the probate division, when it comes time to finalize the adoption, the judge who presided over the Sink case, here's the final adoption.
But
It's
you
the
have to
standard procedure.
You have to understand how that looks, that the judge that consents to adopt then orders the adoption. That seems a bit conflicted, doesn't it?
Your Honor, that's just the standard procedure, and I would remind this court that it was that same district judge that granted the cousins interested party status so that they could appeal. If this was a judge that was trying to undermine that right, it would make no sense why he would have granted interested party status. We wouldn't be here today had he not granted interested party status.
Counsel, I see you are out of time, but would you like 30 seconds to wrap up?
No, I'll just wait for my rebuttal.
Very well. Thank you, counsel.
May it please the court, Lynette Herman from Wichita on behalf of the appellants. And just jumping right in, I think, to the mootness analysis is probably where I'd like to start here. I think it's also important to remember the first section of the Child in Need of Care Code, 382201, in subsection A, where the legislature tells us that when you're talking about a Sink case and a paternity action, or a Sink case and a domestic action, or an adoption action, that the Child in Need of Care case takes precedent. So at this point in time, the Child in Need of Care case in Sedgwick County District Court is still open. And there have been journal entries filed in that case, administrative review orders filed, where the court acknowledges that the case is remaining open because there is an appeal pending. So my argument, one of my arguments anyway, as it relates to mootness, is that the Sink case is still open. The Sink court still has jurisdiction, even though technically it's the same court that concluded the adoption proceeding in this case. But in the event that a mandate comes down that reverses the district court's decision in the child in need of care case, my position, and I think what the district court even had in mind, is that the Sink case would be revived. The adoption at that point in time certainly could be set aside.
Through what mechanism would the adoption be set aside? I mean, this would be a collateral to the adoption proceeding.
Absolutely, and that would be at least my intent, my client's intent, in the event that that occurs.
But what would be the procedural mechanism for doing that?
We would file a 6260 motion.
And is it clear that a 6260 applies in an adoption proceeding?
I think that it's a civil adoption proceedings are civil in nature, and 6260 is a civil statute, and I don't know of any authority or precedent that would show that it is not available as remedy in an adoption proceeding.
Is there any other way showing that it is?
I am not aware.
Wasn't it really a mistake not to go over to the adoption case and file something that said this matter is now on appeal on the consent, and so the adoption should not go forward?
I think so. I think that there was a lot of email exchange in between opposing counsel, the court service officer, that made it pretty clear that the court was going forward with the adoption, and that it was everyone's opinion that it would be just set aside if something were to come back, if the court were to be reversed on appeal. We didn't receive any formal notice of the proceeding other than an email. My clients were not served with any notice. I received an email with an administrative review journal entry that said this is when the hearing is going to be held. There was a lot of considerations that went into standing. I didn't know that I guess maybe I assumed that the purpose of the requirement in Chapter 59 in the adoption statutes of notifying the court of any other proceeding that may be going on as it relates to the custody of the child, that is sort of the responsibility of the petitioner to say yes. And the appellate counsel did that in this adoption, in the pleadings, in the petition, outlining, yes, there is another matter proceeding before the same court that realistically ended up handling this adoption.
So you're saying you couldn't tell this judge anything the judge didn't already know?
Yes.
And you're saying that a first cousin or some cousin once removed may not have standing to stop a adoption proceeding?
That's how I felt in the situation at the time. In hindsight, it probably would have been better practice had we filed. But then again, it was a struggle of what to file at that point in time. We weren't a party that got a formal notice of
I'm going
the
to
hearing.
interrupt you because I don't understand that answer, because in the record there's a journal entry of administrative review in the Sink case, and it shows that you were sent and it indicates that the adoption is going to go forward, and on the adoption is scheduled for December 21, 2012 at 8:30 a.m. in the juvenile department. It's filed December 7th, and it shows you getting a copy of it, and it shows a copy being sent to the interested parties, to the maternal cousins in this case. So when you say you only got emails, the record on appeal would indicate differently. Now, are you saying you never got this journal entry of administrative?
I received that by email. But there was no formal, I guess, as you would normally see.
It's a journal entry. How is that not a formal court document?
And I'm
You've
not
been
alleging that,
electronic.
I guess I probably shouldn't use the word formal, but there was no, it just wasn't how it normally was done.
In terms of the service of it, is that what you're saying?
Yes.
you would normally have received it by mail rather than email?
And, if it's a party entitled to notice of the adoption proceeding, I would have maybe expected the maternal cousins to have been, served by certified mail or, something to that nature. And maybe that wasn't necessarily required. And at the end of the day, it was clear that any objection was not going to be entertained. And to have made things a lot more clean, I wish we would have filed something in the adoption proceeding specifically. But my interpretation is that the child in need of care case is taking precedence, even still today, over any other proceeding as it relates to this child based upon 382201. So I guess my plan had been we would ask that it be set aside as void for the court lacking subject matter jurisdiction at the point that it granted that adoption. As it relates to jurisdiction, I think that there's one important point, and I try to make that anyway in the briefs, but the cases that the foster parents cite, that the appellees cite, are not all custody determinations. The cases before DMM and even the cases after, a lot of those cases are placement decisions where the district court is asked to determine, or the appellate court is asked to determine, did the district court pick the right person? A family member, an aunt versus a grandmother, something like that are construed as being placement decisions. This is different in that it is a custody determination. The court is not just picking between two relatives as to which relative is the most appropriate placement for the child, but the court in this case changed the legal custody of the minor child. So I think that it's important to keep in mind that, for example, in Ray SC, CE, those were placement decisions and not custody determinations. But
Go ahead. I'm sorry, go ahead.
The appellees argue that, the legislature should have done something then after In Re DMM came down, saying the court doesn't have jurisdiction to hear these post-termination custody determinations. The legislature should have responded. But I guess I would argue the legislature didn't respond before DMM was decided to say, oh, wait a minute, you don't have jurisdiction to make those decisions and we're going to go ahead and codify that. So I don't think that is an argument that we can use. The legislature would have responded if the legislature intended for the appellate court to have jurisdiction at this level.
Was DMM unpublished?
DMM was a published opinion.
Okay.
And I think that although the overarching principle should be the best interest of a child in a child in need of care case, the code is also very clear in its not favoritism but deference to relatives and keeping a child in the home of a family member as being presumably in the best interest of a child. And with the interstate compact for the placement of children and the paperwork that has to come from the court as a result of that, I think that the analysis by the Court of Appeals as it recites the facts in this case show that this case went extremely fast when you're talking about adoptive placement with an out-of-state relative. And so I think that just to wrap up at least my argument on the jurisdictional piece is that the Court of Appeals analysis in regards to this being a disposition is accurate, and that these decisions, I don't think the legislature intended for the district court to be the end all. The district court can take a child that's in jurisdiction and under the care, custody, and control of the state of Kansas and unilaterally change that custody to a private individual, potentially even a relative where there has been no foster parent licensing, or we may not, depending on what kind of, we hope the agency completes a very thorough background check and assesses for appropriateness, but at the end of the day, there could be a family member who proposes to the court that the district court that the state did not make reasonable efforts in selecting another family member the district court could change jurisdiction, change custody of the child, place the child directly with a family member that social service agencies have done nothing with because they have not participated or they haven't been approved, and then there is no review by anyone of that decision. And now we've taken the legal custody of that child and put with whoever the district court wants. I mean, that's basically what we would be saying if there's a determination that this decision on a change of custody is not reviewable.
How is that true? Because it gets you back to the same reason that you had the foster parents filing their motion under 2264. I don't see anything that would prevent the maternal cousins from having filed a motion, the same kind of motion, just saying that, okay, you made this decision and this isn't a good decision. It didn't work. And so it doesn't seem like this is, if the court makes a bad decision this time, that it's completely unreviewable. You still have this procedure until the separate court case on the adoption occurs, and then you've got some finality over there. But like the maternal, under your scenario, the maternal cousins could still have filed a motion under 2264H, could they not?
Yes.
Okay.
But our position was that the agency did act reasonably in selecting them as the adopted placement, and that's why we didn't ask to challenge that decision.
Judge Malone, in his dissent, had a criticism of the majority opinion that went basically that under the majority's analysis, the maternal cousins had a right to appeal, but had the foster parents lost on their motion, that they would not have a right to appeal. Do you agree with that criticism that Judge Malone has?
Respectfully, I don't agree with that criticism because the majority's analysis of the definition of disposition included not only a change or initial determination of custody, but a continuance of custody. So in that situation, had the maternal cousins prevailed, that would have been a continuance of the child in the custody of the state of Kansas, which under the Court of Appeals decision would have been, or the district court decision would have also been appealable under their analysis.
And the foster parents had already been given interested party status, had they not?
At the conclusion of the evidentiary hearing, the foster parents previously, yes. I'm getting my people confused, yes.
You, if you prevail before your arguments, with your arguments here today, what happens? What occurs here if you win?
The district court or the child would be placed back into the custody of the state of Kansas. At that point in time, I think it would be up to DCF I don't know how, certainly what we would like to see happen would be then that adoption would proceed immediately with the maternal cousins. Reality though, Department for Children and Families would most likely need to conduct a best interest staffing, hold some kind of staffing to make a determination right now what is in the best interest of the minor child.
Does that staffing then include the fact that the child has been with the foster parents, well actually now the adoptive parents, for the last year and a half?
I think it has to.
That
I think
factors
it's
in.
unavoidable
Right.
at this point in time. My client certainly, and we can't ask for the best interest of the child to be completely ignored. However,
Of course, yeah.
I think that there are, she's just over 2.5 years old. I think that, kids make transitions a lot in.
I understand, but
Essentially, the structure of what happens is that the child goes back to SRS custody, and then a best interest determination is then made, and then what?
And a recommendation is made to the court. The problem there, though, is that I suppose we could be right back here if there's
I was trying
then
to
an
think about how that would all
objection.
work. Right.
I think probably in order to achieve permanency, which is certainly also in the best interest of this child, that if the court were to give direction that adoption proceedings should be initiated with maternal cousins, and that the district court should facilitate that occurring however could be most consistent with the best interest of the child. I'm not sure any other way to avoid the potential cycle.
That's what I was trying to project down the road. It just seems like it's very cyclical, and I'm not sure where, I mean, if the desire is permanency, how the system is providing that in this case.
I think that the system can provide that in this case. I think that there is a way that a gradual integration can occur if we were to prevail, and I think that DCF and its contractors would be able to assist in facilitating that. My clients certainly don't have any expectation of anything other than that in a best case scenario.
Isn't one way to achieve permanency to basically read the statute regarding appeal, to interpret it to cut off any appeals past termination of parental rights?
I think that that is one way to read it, but I think that if a child is not ultimately placed in a, I don't think that the district courts may, place children with pedophiles or, bad people with any intent, but I think that if you want to make sure that the district court really is choosing a placement that is going to be best for the child long term and that is going to work out, that there be the ability for that issue to be litigated after termination of parental rights, because that gives the opportunity for the court to really have the most information about what's going on. I don't think that the legislature would have given us the language and the ability to challenge an adoptive placement decision by the agency if that were really the legislative intent for permanency. Certainly that would be a way to stop any potential litigation, but is that really what's in the best interest in terms of permanency?
To play devil's advocate, if the district court's choice doesn't meet the needs of the child, you still have the opportunity to open another SYNC case.
That is true.
You have the permanency, but you still have a methodology to protect against the bad placement. Not ideal, but a avenue for protection.
Sure, if the child remains in the state of Kansas. Kansas would lose the ability to do that, obviously, if the child were adopted out of state or something like that.
Here's the thing that bothers me, and I don't see that you're arguing against it. The then SRS ruled that it was in the best interest of the child to be placed in an adoptive placement with the maternal cousins. The district court held a permanency hearing and made the same determination. And then, after the foster parents lost their bid for a reconsideration of that determination, they utilized a failure to exert reasonable efforts proceeding to essentially get the district court to decide which placement the district court wanted, instead of what the SRS had determined before and the district court had trumped. And I'm just trying to see why when the issue is the SRS isn't meeting the timelines it should, that's open the door for the district court to make its own determination of best interest of the child or to reconsider, rather than to follow the reconsideration that can happen at a permanency hearing. Tell me why you aren't concerned about that, using one avenue that's designed to protect against one thing to accomplish a reconsideration of another thing.
I hate to, it's the way that it's handled so often in Sedgwick County that I really, until you dig into this, hadn't separated those two very much. I've got, a lot of what we see as a chicken before the egg situation where, do we talk about the reasonable efforts first, or is it best interest first? Is it reasonable efforts first? Is it best interest first? But
I guess the issue on the reasonable efforts is the issue that the SRS didn't select the right person in the mind of the judge. Is that the real issue here?
I think that's the real issue. I don't think that
Even if they're timely, even if, because I agree with you, it appears to me that for interstate compact adoption, this was warp speed, that, there wasn't foot dragging there. But even if the timeline, if we all agreed the timeline was as best as it could be, the court can still find reasonable efforts were not being made because the court didn't like the placement. Is that what you're saying? That's possible?
I think that that's possible. Do I think that's the way that it should be read? No. But I think that, the progress towards finding a fit and willing relative, the fit relative, the word fit, I think, is where then the district court says, okay, is this family, able to meet the needs of the child? Did the agency act in a reasonable way towards finding, not just expeditiously finding a relative, but a fit relative? And I think that word is really where a lot then comes in to the reasonable efforts analysis, talking about which placement is better. I don't think it should be a determination of which is better, but is this person that was selected by the agency fit? And I don't think it should be comparing to, but a determination of, we're not sending this person to a criminal, someone that's going to harm the child.
Counsel, you're out of time. Would you like 30 seconds to wrap up? Or do you think you've made your points?
I think that I made my point.
Any
Thank
further
you.
questions of counsel? Thank you.
Thank you.
We'll reserve 5 minutes for rebuttal.
I'd like to respond to Justice Johnson's question. The concern of the district court was not in the timeliness of the decision that was made. His concern was that only the relatives were considered, only blood was considered, that the agency gave no consideration or no weight to how it would impact the child to be removed from the only family she'd lived with, from the only siblings that she'd lived with, that the agency didn't even consider that. And we've talked a little this morning about the importance of a transition plan. The evidence at the trial court level was the transition plan was that child was going to get on a plane and leave with the cousins. That was the transition. That was the judge's concern, is that there was just woefully little visitation or transition plan. There was no reason why the agency couldn't have invited those cousins to Kansas in November or December and set up visits earlier. They didn't get serious about visits till the summer.
That contradicts what you just said. You said the court wasn't concerned with timeliness. Now you're arguing timeliness.
No, what I'm arguing about is that the court was concerned about the lack of relationship, that the cousins had spent very little time with the child.
And my question is that the touchstone for a determination on whether the agency had made reasonable efforts, progress towards placement of the child? Is it whether the court considered everything it should to determine the best placement?
The court's concern was that you can't divorce reasonable efforts from the best interest of the child, that reasonable efforts will result in a decision that is in the best interest of the child. The court was concerned about an email that was sent in May of 2012 before the child had even met the cousins, before the agency had even reviewed a home study, saying that the workers in the case were certain that the relative would be selected. The court was concerned that the agency was so narrowly focused that they considered nothing else.
Well, the flip side of that was the blood relationship considered enough? Because don't we have a statute that gives the cousins preference over the foster parents?
382270 gives preference to relatives to the extent that a court finds it in the best interest of the child. There is no freestanding statute that gives a relative preference without coupling it with best interest.
True, and here the court found that both couples were appropriate and would be good and fit parents.
That's correct, Your Honor, but the court also found...
So having said that, having that being the situation, that if they're on equal grounds, then the relative wins.
But what is missing in this case, Your Honor, and the court's concern is the lack of effort by the agency to establish any relationship with a child prior to July.
Could you clarify that for me, because the record at least isn't clear to me. I thought the maternal cousins made some efforts to try to have contact, and that the agency said because of the status of a temporary placement of sync care that would not be appropriate. In fact, weren't there numerous efforts the cousins made to try to do that?
Correct, Your Honor. The cousins made efforts, and that's why it's our argument that the agency acted unreasonably. There was no reason why the cousins could not have come to Kansas to visit that child before July of 2012.
And
that
they
was
tried.
a decision the agency made.
And they attempted to, and they actually were very desirous. At least as I read the record, it appears as if they tried to do that.
Correct. And the agency said that, they could have sought a foster care placement with the cousins through the ICPC, but they didn't make that decision. They didn't pay any attention to the cousins, and then in July there was finally a visit, and the court...
And then in August, the court denied a visit. And then when the foster parents filed their challenge, the court would not allow any visitation after that.
That's not true. The court ordered that the visitation remain the same, that visitation not be expanded. But the court did deny a 2-week out-of-state visit because the child had only met the relatives over a course of 1 weekend prior to that. Again, there was no transition.
But the ICPC had already been approved.
The ICPC was approved in August. It could have occurred
And so
under the ICPC.
they asked for the in-home, in Idaho visit after being approved through the Interstate Compact, after they paid the
Correct.
money and got the private home
Correct.
study. And at that point, the court denied the visit.
Correct. Because at that point, there had been no efforts by the agency to really develop a relationship between the child and the family. And it was the testimony of Jan Van Patten, the licensed clinical social worker, that a 1-year-old child being removed from the only caretaker would experience trauma. This was a child with risk factors. She was born premature. She was born positive for cocaine. And according to the testimony of the social worker, exposing this child to trauma makes the child more likely that these negative genes will express themselves. And the agency gave no consideration to any trauma that might occur to the child. In child neonatal care cases, the adults need to adapt to the needs of the child, not the child to the needs of the adults.
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement.